oh yay, this Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Yes. Good morning, everyone, and welcome. We're pleased to have you with us today. We will call the docket in the order in which it appears, your cases appear. Each side has 15 minutes for argument. The appellant may reserve up to 5 minutes out of that 15 for rebuttal. Are there any announcements before we call the first case? Hearing none, please call the first case.
David Lynch Sr. et al. Versus Bradley E. Poe et al.
Good morning and welcome.
Good morning, Your Honor.
I want you to know that you're the first attorney to appear in this courtroom in 22 months to present a case before the Court of Appeals. So congratulations. So don't mess up.
Lots of pressure.
Yes, sir.
We were actually remarking about that in the post-COVID world, not only is this the first time I've been here, but we haven't been in court a whole lot. I've had some motion arguments, but everything's by Zoom, and it's a strange world.
We held court at Belmont University School of Law 2 weeks ago, but we're glad to be back in this very historic, traditional room. Thank you.
Once upon a time, I worked for Justice Birch, and this is
wonderful.
It's an interesting place. I want to make two motions, Your Honor, before we start the argument. The first, I have a visual aid that I was going to present to the court, and just because of line of sight and visibility, I was going to ask for permission when it comes that time. I was going to ask for permission to move that up there, and when it comes time to leave the podium and illustrate what I want a little bit closer to Your Honors.
I think it's fine where it is.
Okay.
If you'll just turn it so all three judges can see it. Have you seen it? Would you look at it and let us know if you have any opposition?
And Your Honor, this is from the appellate record. It's an exhibit from one of the depositions.
Any opposition? Very good. All right.
The other motion, Your Honor, we've got a little bit of an unusual situation because as customarily, the time is divided 15 minutes per side. We're in a bit of an unusual position because we've got two appellants, but we are adverse to one another. I was going to move the court to expand the time by about 5 minutes to see if we can have a little extra time so we're not stepping on each other's toes.
Well, respectfully, I think that's a late motion, so we'll stay with the 15. And have the two of you agreed to divide the 15?
We have.
Okay, and how much time are you going to keep?
I am going to have 10 minutes. Mr. Lipscomb is going to have 5 minutes. Of my 10 minutes, I was going to reserve 2 minutes for rebuttal if possible.
Very good.
Time will be tight, so I may run into that.
We'll set your original time for 8 minutes then. Please proceed.
May it please the court, as I said, I'm Brian Dunnigan. I represent David Lynch, the plaintiff appellant in this matter. This is a summary judgment appeal. When the trial court granted summary judgment in this case, the court glossed over a couple key evidentiary points that we feel make summary judgment inappropriate. And I'm going to address those. It's kind of a two-pronged argument. The first prong addresses duty. The second addresses notice. So I'll take them in order. Looking first at duty. This case involves, as Your Honors I'm sure are aware, scaffolding that was put together wrong. Lacked a safety guardrail at the top. The defendant homeowner, Bradley Poe, set up the scaffolding, but there is evidence in the record that shows that he relied on Direct Scaffold's expertise in how to do it. And in fact, when the court reads his deposition in the record, you come away with the inference that Mr. Poe wouldn't have been able to set up this scaffolding on the backside of the house at all without the expertise of Direct Scaffold and their guidance. He testified that there were issues with assembly. He didn't know how to get around the exit doors. He didn't know where certain parts went. He didn't know what to do until Direct Scaffold advised him, and there is testimony in the record from Direct Scaffold's sales manager, Jeffrey Farrell, that they were on the scene multiple times.
And when you say multiple, how many times is multiple?
Your Honor, from our perspective for summary judgment, anything over one would be plenty. I don't think there was ever a count. I don't think anybody said there was 2 times or 5 times. Everybody agreed, though, Your Honor, that there were multiple times that they were out there. They were out there on a regular basis. Mr. Farrell said that they were there regularly as the project went along to, quote, make sure it was set up somewhat correctly.
Are you suggesting that the company told him something that was inaccurate that caused this accident?
No, Your Honor, this is an omission. They didn't tell him what they should have told him. They gave him guidance about safety. You'll see in the record that Mr. Farrell talked about helping Poe on stuff that was, quote, an ocean nightmare. And Farrell knew what these safety rules are. That's clear. And as he went forward with these ocean nightmare issues, he should have been clear that Mr. Poe was not knowledgeable about the safety rules. And once he started down that road, once he started giving advice on safety and realized that Mr. Poe didn't know what he was doing.
So were there any statements from Mr. Farrell that the cinder blocks, other than the cinder blocks being an ocean nightmare instead of using jacks, any other instance where Mr. Farrell said any other part of the scaffolding was an ocean nightmare?
Well, with the quote ocean nightmare, that was specific to the leveling blocks, but this goes to whether he was advising about safety. There was also an issue where Direct Scaffold advised Mr. Poe that he needed to have the working levels of the scaffolding fully planked. That's in the record at page 37. They talked about height restrictions and whether the scaffold needed to be attached to the house. And so that's the point, is Mr. Poe was getting some safety advice. Once he's getting that safety advice, it can't be done in half measures.
So did he get any advice regarding the top railing?
He did not, and that's the problem, Your Honor. He should have. And so this goes back to the Bennett and Biscan cases that are cited in my brief. Once you assume to act, even though gratuitously, you then become subject, I'm quoting from Bennett, you may thereby become subject to the duty of acting carefully. And the duty of acting carefully would be when you know you're giving advice to somebody who doesn't know what they're doing with scaffolding. You can't tell them, well, you need to do this and you need to make sure it doesn't need to be attached to the height. You need to follow a height restriction. But then if you're in a position where you knew or should have known that the top rail was not constructed accurately or safely, then they should have gone that extra length and given him that advice. They should have recognized that there was a hazard. They should have known that Mr. Poe was relying upon them in order to construct this safely.
Wasn't there evidence the workers took it off?
And that comes to the second point about notice, and that is one of the biggest problems with the summary judgment in this case, Your Honor. The trial court looked at that testimony that there were top bars that were removed from the scaffolding to place ladders. And the court makes a finding in granting summary judgment that Mr. Poe, quote, installed all of the bars before any of them were removed. I guess I'm paraphrasing. I shouldn't have said I'm quoting because I'm not reading it, but said that he installed all the bars, and then essentially after Direct Scaffold left the scene, then these bars were taken away. If that were the case, and if that were the undisputed facts, then Direct Scaffold would not have a duty. But that's a disputed fact. That's why I brought this. I think a picture is worth 1,000 words here. Mr. Farrell testified in his deposition that this top area should have been like this area here with a crossbar. This second level has a crossbar. This top level, Your Honors will see, and it's a bit hard to see. I do have extra copies of the picture if you want to look at it closer.
It's in the record.
Okay.
I know I've seen it.
This is Exhibit 1 from Farrell's deposition. If you look at first you think there's 3 bars. There's a top bar here that goes all the way across, and there's a bottom bar, and it looks like there's a bar across the middle. Now, if your honors look closely, this middle bar is not part of that front railing, because this middle bar comes and attaches to the back support here. So it's actually behind. You have 1 bar in the back, you've got 2 up front with a gap between them.
And when you say the front railing, you're referring to the part that's farthest from the house?
Correct, Your Honor. Front as you're facing the picture. So in the area where Mr. Lynch fell, there's a top bar and a bottom bar. There's a plank there. There's a space here. Now, what Mr. Farrell testified as far as the proper construction of these is that this should have been higher. There should have been guardrail posts, and it should have had the crossbars. And we know that this was not a matter of a crossbar being removed for the railing, because Mr. Farrell identified the crossbars never used down here at the bottom of the scaffold. They're there. They were never put in place in the first place.
Mr. Dunnigan, let me ask the question. Is there any evidence in the record that the scaffolding was intended to be or should have been a safety net for someone who falls from the roof as opposed to someone who falls from the scaffolding?
Well, that would be the purpose of the guardrail.
Is there any evidence that the scaffolding guardrail is intended to be a safety net for someone who falls from the roof?
Right. The evidence in the record would be that if the guardrail were there, it would have stopped this fall. That goes into inferences on summary judgment. We do have to make the inferences in the light most favorable to the non-moving party. If this had been higher and had been constructed properly, a fall for the roof would have been stopped or could have been stopped by the rail, and it wasn't there.
All right,
I think that's my time, Your Honor.
We'll hear from you further on rebuttal.
Thank you.
We'll now hear from the other appellant. Good morning.
Owen Lipscomb for the homeowner appellant Brad Poe. I will be very brief.
Mr. Lipscomb, we're pleased to have you. Would you like to reserve some of your 5 minutes for rebuttal?
No, sir.
All right,
I yield to Mr.
We'll set the time at 5. Thank you.
Our position is simple in this case. Judge Jones committed an error when he ruled in favor of the motion for summary judgment because he went ahead and ruled on the material issues of fact. And it's our understanding of the law that he is not to weigh the evidence, he's not to decide those, but he's supposed to determine if there are material issues of fact.
Which material facts do you believe are in dispute?
We think there are 2 material issues in the fact, and the court has already touched on them, frankly. First, the first issue is whether or not the rails that Mr. Dunnigan was pointing to were actually ever up. My client, Mr. Poe, indicates that he did put rails up and that H.E. Palmer employees removed them from day to day, and he would go back up there and put them in place. However, in his deposition, Mr. Farrell, who was the designated employee or sales rep for Direct Scaffolding, testified that the rails were not there. They never were. He looked at this picture and indicated they weren't there. So that's the first issue of fact we believe that a jury should decide. The second issue, Your Honor, is whether or not Direct Scaffolding, in fact, assisted my client with the erection of the scaffolding. My client says, well, he admits that he did not purchase the service to set it up and that he intended to do it himself. However, as it evolved, in reality, he did take advice from them. His term was, they helped me engineer the scaffolding. And yes, it did involve setting it straight, but as Mr. Dunnigan points out, it also, the issue is they didn't go far enough. Once they undertook to advise my client, they knew he didn't know what he, frankly, they knew he didn't know what he was doing. And they didn't tell him about additional railing or that they needed to be in place. So that's the second issue, is whether or not they actually undertook to assist him to engineer this scaffolding by their comments and statements to him. And we believe those two issues are material because, again, as Mr. Dunnigan has alluded to, if the trier of fact decides that those rails were never in place, then that creates a duty on DSS or direct scaffolding to so advise my client, hey, look, you need to get this up here. That's not even OSHA compliant. You need to have them there. If, on the other hand, as Mr. Dunnigan has said, they were there and it was H.E. Palmer removing them, then I agree. Direct scaffolding is not appropriately in this case. But that is an issue for the jury to decide, not for Judge Jones to decide, and he went ahead and did so in this case. And it's our position that that was a mistake and that the court ought to set his decision aside and remand it back for those issues to be decided by the jury.
Anything further?
No, sir, that's my
All
time.
right. Thank you, Mr. Lipscomb, for
Thank
your argument. All right, we'll now hear from the appellee.
A little bit longer of a walk than I was expecting.
That's quite all right. Do you want us to move that, or is that bothering you?
It is fine.
Very
I
good.
believe.
Thank you. All right. Please, Ms. Bassett?
Yes.
Please,
Yes, Judge.
Please proceed.
Thank you. Good morning, Your Honors. My name is Laura Bassett, and I'm here today on behalf of Contractors Access Equipment Jackson, which is also known as Direct Scaffold Services, or DSS. And I believe the instructions also said to note that Bruce Gill was on brief for this argument, and I was not.
All
okay.
right. But we're pleased to have you here, and
Thank
I'm
you.
sure you'll do a much better job than Mr. Gill.
Thank you, sir. The trial court did not err in granting summary judgment to my client under either a premises liability theory or a general negligence theory. We state that there was no problem in granting summary judgment under a premises liability theory because there was no actual or constructive notice, and similarly, there was no ownership or control by DSS about or in regards to the property. We did, at the trial court level, argue that this was a premises liability theory, or this should be decided under such, because the gravamen of the plaintiff's second amended complaint, which brought in my client to this case, sounds in premises liability.
And the trial court agreed with that theory, right?
Yes, sir. Yes, Your Honor. They did indeed. And they found that there was no liability under either a premises liability theory, or the trial court went the extra step and said that they also found no duty if this case were to be heard under principles of general negligence, as the other parties asserted that it should have been. In terms of the premises liability, as I said, my client had no actual or constructive notice and no ownership or control of the property. Ownership and control is very obvious in that it was not DSS's property. It was the property of Brad Poe. And in terms of control of the actual scaffolding on the premises, we actually disagree, obviously, with what you've just heard from the other counsel in this case. Brad Poe did...
There is evidence that Mr. Farrell assisted or advised Mr. Poe from time to time on construction of the scaffolding, and the plaintiff, the other defendant insists that Palmer, I'll get it right in a minute, forgive me, insists that your client thereby assumed a responsibility, even though gratuitously, and cites an important case that's very well established. So what do you say to that?
Absolutely, and thank you for that question, Your Honor. We do actually see some big disparities in Biscan and also in the Bennett case with this current case. Specifically in Biscan, the court was dealing with an adult host, as Your Honors obviously know, an adult host of a party where alcohol was being served to minors and ultimately led to an alcohol-related car accident with
And the
catastrophic
adult
injuries.
host took the keys from all of the children, or except didn't.
Correct. He set a rule and then he never followed through with it. He didn't actually actively patrol the party to ensure that everybody in that case, or at that party rather, was staying the night as he had set the rule. The court specifically said that they found a special relationship in large part because we have long recognized that immaturity and experience, because of immaturity and experience, I apologize, a duty may exist towards minors where it might not exist towards adults. And I specifically picked out that portion because what you have just heard is all about Brad Poe's inexperience with scaffolding and with renovation projects, when in actuality, the record reflects that Brad Poe was a licensed contractor for about 6 years. He also had undertaken several renovation projects and was very familiar with supervising the landscape. He also, if nothing else, he also represented to Jeffrey Farrell, as was testified, that he had people who were going to be setting up the scaffolding. So it's not necessarily that DSS knew or should have known that Brad Poe was either inexperienced or should not have been setting up the scaffolding himself, because...
But isn't it undisputed here that Mr. Farrell, if not offering advice, offered some commentary about the construction of the scaffolding?
Mr. Farrell was providing commentary on whether the correct parts for the scaffolding were present on the site. Actually, Judge McBrayer, you asked one of the other attorneys how many times was DSS out there, and specifically for Mr. Farrell, we put in our statement of facts for our brief that he testified to only being there one time, or actually that may have been Poe that testified that Jeffrey Farrell was only out there one time. And then the other times that people from DSS were out there, they were bringing additional pieces of the scaffolding that Brad Poe realized he needed to further construct the scaffolding.
So this multiple times that is being relied on here are multiple deliveries of pieces of scaffolding?
That's our understanding from the record. Yes, Your Honor. And so in terms of the assumption of the risk, we obviously dispute, or not assumption of the risk, I apologize, assumption of the duty, we obviously dispute that. Additionally, in Biscan, just to go back to your question, Judge Clement, the harm that the party host was seeking to avoid was exactly what happened. In this case, it was not reasonable to think that in DSS advising of what parts were needed for the scaffolding and allowing somebody to purchase a service which did not include the construction of that scaffolding, that somebody would then fall off the roof and not have guardrails there. And I would like to echo what Mr. Lipscomb said in that Bradley Poe did testify that he had installed all of the bars on the scaffolding. So to that point, that is in the record as well, that he did install all the bars. However, just to skip around a little bit, going back to Mr. Dunnigan's lovely picture here, when this picture was presented to Jeffrey Farrell during his deposition, first of all, there's no date on it. We do not know when this picture was taken. We do not know what day it represents or anything about that. It was not told to him about that. Additionally, Mr. Farrell also testified about this picture that if the footboards had been in a different position, then it wouldn't have needed the higher height on the scaffolding. This goes to the fact that scaffolding changes every single day, and to impose any sort of to say that my client assumed any sort of duty when they were not actively on the site based on comments that were made about the parts needed to engineer the scaffolding, or, in my mind, even worse, to state that my client would be required, even though the homeowner chose not to purchase a construction service, would be required to force that upon somebody based on their own assumptions about that person's ability or ability to construct the scaffolding themselves or the ability to hire someone else to do it, does not make a lot of sense.
Is there evidence in the record to support your statement that the scaffolding configuration might change every day?
The testimony that I'm specifically pointing to is Jeffrey Farrell. I don't have the exact quote in front of me, but he testified that the tradespeople are the ones that ultimately move pieces on the scaffolding from day to day. And if you have a footboard, I believe is what it's called, the footboard in one position might not require the guardrail posts that lift up the pieces that make the top piece of the guardrail higher. But if that footboard is then moved, then you do require the extra elevation of the posts.
So there's evidence in the record that regardless of who erected or set up the scaffolding, the trades, for example, a roofer could reconfigure a part of the scaffolding to suit his or her needs at the time.
That is my understanding of the record, Your Honor, yes. And again, since my client was not consistently out there, there would have been no actual or constructive notice to any given changes that may have been made from day to day about that scaffolding. So certainly under a premises liability theory, we think that there's no liability on our client because, again, there was no actual or constructive notice that there was any allegedly dangerous defect on the premises caused by the scaffolding. And even under the general negligence theory, we still assert that there was no duty by DSS towards either party. We, again, just assert that there was not reliance by Brad Poe on any statements that were made to DSS. Judge McBrayer, you asked if he got any guidance about the guardrails. And no, he did not get any guidance about the guardrails from DSS, but also it's not my understanding from the record that he ever sought any guidance or, again, sought to purchase an OSHA-compliant erection of the scaffolding until after Mr. Lynch fell. That was always a service that was offered. Brad Poe testified that he, even if he didn't specifically know it was offered, he assumed that it would have been offered. And again, with his prior experience that he did have in the construction industry and in the renovation industry, certainly he should have known that it would have been offered, and he chose instead to represent to Jeffrey Farrell that he would have somebody else put up the scaffolding.
Did Mr. Farrell or anyone else testify regarding the purpose of guardrails on the scaffolding? And it might seem obvious that a guardrail on the scaffolding is to protect someone from falling from the scaffolding. But was there any evidence that it was also to protect someone from falling from the roof onto the scaffolding?
Your Honor, I'm not immediately certain whether that testimony is in the record. That's certainly something that I would be happy to look up afterward.
Oh, we'll look for it.
Okay. I think we've kind of covered most of the things that I intended to cover. I will just also say about the Bennett case, which obviously, as you've heard and as you know, another Tennessee Supreme Court case cited by Mr. Lynch's counsel that also piggybacks off Biscan. Again, we find that one distinguishable because of the representations that were made by Tribeca Nazarene's employees that it was a low voltage that was being dealt with, and obviously after the fact it was determined that the voltage was something like 10 times as much as the voltage that they were told they were dealing with. And as such, the people then were not experienced enough, not specialized enough to be dealing with that, and through that were ultimately burned by the explosion that happened. DSS never represented to Mr. Poe that his scaffolding construction was an OSHA compliant, that it was done in an OSHA compliant manner. This representation was not made. They did not sign off on anything. In fact, Jeffrey Farrell testified that DSS did not ever rubber stamp anybody's construction as being OSHA compliant. Like, they would have to go out and specifically inspect it if they were not the ones that put it together.
Does the record here establish when any representative or employee of your client was last on the property before the accident occurred?
To my knowledge, nobody was able to exactly pinpoint the last date that anybody from DSS, to my knowledge, that would have been Mr. Farrell, if it was anybody, was last out on the property. That it was testified, though, by Mr. Poe, I believe, that he did not remember anybody from DSS being present on the day that Mr. Lynch fell. So, but as to the actual specific last date, I'm not certain. And then just to add one last thing, again, we do not feel that there was a special relationship or any specific third-party duty that was owed by DSS in this matter. There was nothing that was undertaken. It's clearly distinguishable from the Biscan case because any statements that were made about the parts needed to construct the scaffolding to make sure that Mr. Poe had all of the pieces that he would need would not have attached any sort of duty. There were no statements that were made about the guardrails or any specific component that is alleged to have been the defective part of the scaffolding in this case. And as such, we say that there's no duty in addition to no constructive or actual notice under a premises liability theory. Thank you.
Thank you, Ms. Bassett. We'll now hear rebuttal from Mr. Dunnigan.
May it please the court, got to skip around a little bit, time is short. Number one, we'll talk about disputed facts in the records. Opposing counsel's argument highlighted a few of these. The first was she made an argument that was hinged upon Mr. Poe's level of experience. He's a licensed contractor. How much did he know? There's testimony that he had experience, but there's also testimony that he had no idea that safety regulations applied here, and there's testimony that he didn't really know how to construct this scaffolding. As I said on direct argument, that he wouldn't have been able to assemble this scaffolding on the back of the house without DSS's guidance. So that is a question of fact. It could come out either way at trial, but this is not the trial. There is a question about the frequency of DSS's presence on the site. Opposing counsel talked about, Mr. Farrell said he was only there one time. Mr. Poe testified that they were there, quote, quite often. It's in the
They were there,
30s.
Mr. Farrell was there quite often, or DSS?
Just representatives from DSS, but
Okay.
Mr. Farrell's
So-
not the defendant as much, DSS is the defendant.
So is the claim then from the homeowner that he received any advice from anyone other than Mr. Farrell?
Well, Mr. Poe's testimony was that he got guidance from them quite often. And so,
Them without describing who them.
without describing who gave him guidance, but somebody from DSS was giving him guidance and telling him what to do. Mr. Farrell's deposition at page 59 says that the purpose of the visits, not visits singular, but visits, was just making sure that the scaffold was set up, somewhat correctly. And so, the correct setting up of the scaffolding should include this safety consideration. And again, as far as questions of fact, opposing counsel highlighted that there is no date on this photo. A jury could infer that this is after. A jury could find that it's before. A jury could make findings about whether or not the trades reconfigured this, or as we submit, these rails that should have been up here were down there from day one, and people from DSS were on the premises multiple times giving guidance and should have seen it and didn't. A
It
jury
does
could
seem
find
odd
either
that
way.
someone would take the time to take a photograph of the beautiful scaffolding before any sort of incident occurred at the property.
Well, but a jury could make the inference that Mr. Poe is making this remodel to his house and was taking pictures as he goes along. And frankly, I do not recall, and I don't think the record reflects the source of the photograph. That's something we can get into at trial. But again, from summary judgment, we've got to look at this in the favor of, in the light most favorable to the non-moving party. And I think that's my time.
Thank you, Mr. Donegan and Mr. Lipscomb and Ms. Bassett, for your arguments. We will take this matter under advisement. Before we call the next case, we'll give Mr. Donegan a moment to reposition the exhibit, and you're free to stay or to exit and get back to your other responsibilities.